Please turn off your mobile phone or set it to silent mode during the seminar. Simultaneous interpretation between Japanese and English will be provided during the event. If you wish to use the simultaneous interpretation service, please pick up an interpretation receiver at the reception desk. Channel 1 is Japanese, Channel 2 is English. Please return the receiver to the reception after the seminar. Please be careful not to leave it back to home by mistake. After the event, a networking session with light refreshment will be held from 10 p.m. today. We hope you will join us. Thank you for your cooperation. We will start the event shortly.
シャルダル・シュルフ、シャルダ・アマンチャンド・マンダルダス法律事務所チェアマン、そして友人の皆様、お集まりの皆様方、こんにちは。本日、皆様をこちらのセミナーにお招きできますことを深く嬉しく思っております。この度、インドのエネルギー業界における機会という題しまして、いたします。
Friends, in these 75 years, India has become one of the fastest growing economies in the world, with a population of over 1.4 billion people. As our economy continues to grow, so too does our need for energy. This has created numerous opportunities in India's energy sector, which we are eager to explore with our partners, including in Japan. While we continue to grow, we also remain committed to strengthening cooperation on sustainable and clean forms of energy, including nuclear and renewables. Explore possibilities for collaboration in hydrogen-based energy, ammonia, ocean renewable energy, while also continuing our efforts for cooperation in use of clean coal technology. India's commitment to combat climate change was reflected in COP26, where we announced the target of achieving net zero emissions by 2070. We all know that Japan is a world leader in the field of energy, with a strong focus on renewable energy sources and innovative technologies. We believe that India and Japan can work together to create a sustainable and efficient energy system that benefits both our countries. Our special strategic and global partnership has expanded across all domains, from historical people to people and culture to political, security and economic linkages. This partnership, based on the strong foundation of shared values of democracy, freedom and respect for rule of law, continues to respond to the challenges and opportunities of the evolving times. The collaboration between our two countries has already yielded many successes, and we look forward to continuing this partnership in the future. Dear friends, India appreciates Japan's participation in India-led international frameworks such as the International Solar Alliance, ISA, and the Coalition for Disaster Resilient Infrastructure, CDRI. We look forward to Japan's participation in LEAD IT, a joint initiative of India and Sweden. Our two countries announced the India-Japan Clean Energy Partnership in March 2022, coinciding with the Prime Minister Kishida-san's visit to India. The partnership aims to promote energy cooperation between India and Japan through diverse and realistic energy transitions, utilizing all energy resources and technologies to ensure energy security, carbon neutrality, and economic growth. For today's session, I am given to understand that we will be discussing some of the key opportunities in the Indian energy sector. Our speakers will also discuss issues regarding dispute resolution system in India and the recent trends in investment relations. We invite you all to join us in exploring these opportunities and working together to create a bright and sustainable future for both our countries. Before I conclude, let me seek your attention to the G20, which India holds the presidency now. In his op-ed in Japanese newspapers, Prime Minister Modi ji wrote, India's presidency will work to promote universal sense of oneness. Hence our theme, One Earth, One Family, One Future. He continued, today the greatest challenges we face, climate change, terrorism, and pandemics, can be solved not by fighting with each other, but only by acting together. I would like to sincerely thank Shardul Amarchand Mangaldas and Mori Hamada for making today's event a reality. I would also like to thank all our speakers for joining us today. I look forward to a very informative discussion today. Thank you once again for attending this seminar, and we look forward to a productive discussion. Thank you.
Thank you, sir. Next, I would like to request Mr. Sheldon S. Shaw, Executive Chairman, Sheldon Amarchand Mangaldas and Co. to give a keynote. 続きまして、シャルル・アマルチャンド・マンガルダス、エグゼクティブ・チェアマン、シャルル・エス・ショー様より基調講演をいただきます。
Namaste and konnichiwa to all the distinguished guests attending today. It is with great pleasure and immense honor that I address the opening session of the seminar on opportunities in the India energy sector, the overview of regulatory and dispute resolution aspects in India, and the recent developments in Japanese-India relations. This has been organized by the Embassy of India in collaboration with my firm and Mori Hamada and Mitsubishi. I'm thrilled to mention that this year marks the 70th anniversary of diplomatic relations and cooperation between Japan and India, as the learned ambassador just mentioned. As we embark on the new era of Japan-India relationship, focusing on strengthening bilateral ties and capitalizing on the convergence between the two nations on geopolitical, geo-economic, and geostrategic fronts. It is crucial to reflect on the achievements of our past and key takeaways that will guide our cohesive and collaborative journeys through the future. The fact that we are celebrating this historic relationship between Japan and India reflects what I see as the immense optimism and anticipation of the concerted and unified growth potential of the two countries. It is quite remarkable to notice that while India has assumed the presidency of G20, Japan is also in a similar pilot position as far as G7 goes. And this also shows the linkage between our two democracies. To begin with, the Indo-Japan economic cooperation is a crucial aspect of the special strategic and global partnership between these two nations. Japan is the 5th largest investor in India, with a cumulative foreign direct investment equity flow of approximately US dollars 8.13 billion in India from April 2000 to September 2022. Among the most prominent sectors which have attracted FDI from Japan are electrical equipment, general machinery, pharmaceuticals, financial sector, construction, transportation, and services sector. The two countries are constantly striving towards expanding the width of the strategic relationship and exploring investment avenues for Japan in India. During the recent visit of the Honorable Prime Minister of Japan, Mr. Fumio Kishida, to India on March 19, 2022, the two economies have expressed their intention to realize Japanese 5 trillion out of the investment and financing from Japan to India over the next 5 years. It is pertinent to note that Japan is the only country that has dedicated industrial townships across India, also known as Japanese Industrial Townships or JITs. As of February 22, there are 114 Japanese companies operating across these industrial townships. Another notable fact is that as of June 2022, a total of 1,439 Japanese companies are registered in India compared to a mere 550 such companies in 2008. And they have 4,790 business establishments in India, which of course include liaison offices, branch offices, and local subsidiary companies. It is important to look into the future and explore the prospects of adding further dimensions to this strategic partnership. And one of the main opportunities is clearly in the renewable energy sector, which my colleague, Mr. Jatin Ahuja, is going to deal with. India ranks third as per the Ernst & Young Renewable Energy Country Attractiveness Index after USA and China. India is the third largest producer of renewable energy in the world with a combined installed capacity of around 163 gigawatts of renewable sources of energy in India as of August 2022. These comprise of solar, wind, small hydro, large hydro, and biomass. We are committed to increase this 3 times in the next 5 years. And that's an amazing expectation, and India is known to have done this on time and in a manner which reflects the growing need for energy across India. The renewable energy sector has been one of the most critical sectors under the Made in India scheme of Modi government. Recently, the government has approved production-linked incentives or the PLI scheme for high-efficiency solar photovoltaic modules for the purposes of enhancing integrated domestic manufacturing capacity of such solar PV modules. And in the union budget of 22-23, the government has allocated USD 2.57 billion for the same. In addition to this, in furtherance, our Honorable Prime Minister announced at COP26 that the Ministry of New and Renewable Energy has constituted a committee to prepare a roadmap and fulfill its commitments towards achieving 500 gigawatts of installed electricity capacity from non-fossil fuel by 2030. This is why I said that it is almost 3 times the current installed capacity in India. The FDI regulatory regime is also favorable to investment in the sunrise sectors such as renewable energy. Under the existing FDI regulatory regime, FDI up to 100% is permissible under the automatic route in the renewable energy sector. Over the last 7 to 8 years, around $70 billion has been invested in the renewable energy sector in India. From April 2000 to September 22, the last 3 years, the cumulative FDI equity inflow in renewable energy is $13.03 billion, amounting to 2.12% of the total FDI inflow. I would like to emphasize that India and Japan are constantly working towards energy cooperation, as is evident from the fact that the two countries had announced the India-Japan Clean Energy Partnership, or the CEP, on March 19, 2022, which focuses on energy cooperation through shared resources and technologies, particularly in energy segments and other segments such as electric vehicles,
solar PV cells, wind energy, use of LNG, and emerging fuels, including biofuels and compressed biogas. It is notable that several Japanese companies have already made their way towards expanding investment opportunities in the Indian renewable energy sector. For instance, in March 2021, the Oryx Corporation, a Japanese entity, acquired 21.8% shareholding in Greenko Energy Holdings, a major renewable energy operator in India, and simultaneously integrated its entire wind power generation business into that entity. Thus, it can be inferred that there is a vast potential for Japan to consider aligning its investment goals with the renewable energy sector, given the underlying growth prospects and favorable regulatory environment. There are two or three other segments that I will briefly touch upon, and fintech is one of them. Fintech is another sector that has witnessed exponential growth in India. India is the world's third largest fintech ecosystem with the highest fintech adoption rate globally of 87%, which is substantially higher than the global average of 64%. In 2021, the market size of India's fintech industry was US 50 billion and was estimated to be US 150 billion by 2025, just 3 years away, 3 times. To further strengthen the fintech ecosystem and attract foreign investment in this sector, a world-class fintech hub has been developed in the International Financial Center, Services Center, or the GIFT City in Gandhinagar, Gujarat. Both Japan and India have shared interest in promoting startups. The two nations have a dedicated platform called Japan-India Startup Hub to promote Indian and Japanese sharing startup ecosystems and joint innovations in startups. Again, India has emerged as the third largest ecosystem for startups across the globe, with over 77,000 DPIIT recognized startups as of August 2022. The Indian unicorns are constantly flourishing in the fast-paced, dynamic Indian economy. Over the last 4 years, there is an exponential growth of 66% annually in the number of additional unicorns being added every year. As of September 7, 2022, India is a home to 107 unicorns with a total valuation of US $340.79 billion. In the light of the favorable investment milieu and the exponential growth in recent times in fintech and startups, there is a huge potential for Japanese entities to expand their investments in these segments. There are 4 initiatives which have been taken by the government which are noteworthy. The government of India is committed to enhancing the ease of doing business and enabling an investment-friendly environment in India through its incentives and initiatives. The Product Linked Incentive Scheme, or PLI, has been extended to several sectors such as electronics, food processing, pharmaceuticals, telecom, automobiles, etc. Secondly, the National Single Window System is a digital single window portal for filing for business approvals across various sectors and under different departments and ministries of the central and the state governments, which is unique. The BM Gati Shakti, a digital platform for multimodal integrated infrastructure connectivity, is another remarkable example of how the nation is moving. And lastly, the FDI caps in telecom have been raised to 100% which is of particular significance to Japan, given its advance in the framework of telephony. Apart from these 70 remarkable years of Japan-India relationship, the underlying significance of 2022 is that it also marks the commemoration of 40 years of Suzuki in India. The success of this joint venture, initially with the Government of India and now as a standalone automobile company, has transitioned and reformed the entire automobile sector in India. In the recent past, Japanese companies are looking to invest in emerging and non-conventional sectors like renewable energy, digital technologies, and health care to invest in India. There is a general sense now that the Indian market has become more lucrative for investment, even by small entities or the MSME as we know them, and startups. As I have stated previously, the investment opportunities in emerging sectors like fintech also marks a notable government initiative towards the ease of doing business. My colleague, Ms. Bincy Susan, is also going to take you through some of the dispute resolution enhancements and speed that has been brought into resolving and enforcement of disputes. As we celebrate the successful 70 years of Japan and India working in a joint fashion towards the progress of both the economies, we are optimistic about the future and are looking ahead to greater investment prospects from Japan to India, marking positive returns to both the economies. Thank you so much.
Next, I would like to request Mr. Jatin Aneja, National Practice Head, Partner, Project and Infrastructure, Chartered Amarchand Mangalidas and Co., to give a presentation on opportunities in Indian energy sector, overview of regulatory aspects. 続きまして、シャルドル・アマンチャンド・マンガルダスコ、プロジェクト法規制面の概要についてご講演いただきます。どうぞよろしくお願いします。
Good afternoon, ladies and gentlemen, and respected ambassador. I'm going to give you a brief overview of the opportunities in the Indian energy sector and the regulatory aspects of the same. Just driving straight into the presentation, these are the aspects that I'm going to cover. So, broadly, I'm going to cover the energy market forecast, investor-friendly regime, new opportunities, green energy consumption in India, policy incentives. In particular, I'm going to cover green hydrogen and ammonia, which is supposed to be a new area for investment into India. Our impetus on oil and natural gas consumption in India, regulation of natural gas pipelines, and the way forward in the energy sector. So let's first get into the energy market outlook in India. So India is seeing an exponential growth in the energy demand this decade, with demand climbing 3% annually, and this is largely due to urbanization and industrialization in India. And interestingly, renewable energy is expected to meet as much as 60% of the growth of demand of power in India. While coal will continue to meet a third of our overall energy demand, to our minds, most future demand is sought to be met through either renewable energy or green hydrogen. Natural gas demand is projected to reach 115 billion cubic meter by 2030 from 66 BCM as of now. The growth is obviously bolstered by manufacturing and other industries, further helped by the expansion of city gas distribution networks, India's oil demand is sought to rise from 4.7 million barrels per day in 2021 to 6.7 million barrels by 2030 and 7.4 million barrels per day by 2040. So there is a huge demand, as you see, which is there in India. And the next question which arises, how is it able to meet this demand? So first, let's get into the investment regime in the country. So we've got a really friendly investment regime. India received FDI of $84.8 billion in 21-22, which is higher than approximately 3% over the last year. 100% of the FDI is allowed under automatic route and the renewable generation and distribution projects. 100% FDI is also allowed in petroleum and natural gas and thermal power projects, whilst 49% FDI is allowed in the petroleum refinery sector in India. We also have investor-friendly regimes of the nature of special investment vehicles, wherein we can invest through foreign portfolio investors or foreign venture capital investors, which are tax beneficial and so forth. In terms of new opportunities in the sector, the government has announced sovereign green bonds. This is akin to, I would say, environmentally friendly municipal bonds, and the aim of this is to only invest government money into environmentally friendly projects. We've also announced the National Infrastructure Pipeline. This was launched in August 2020. This is going to attract investments in key greenfield and thermal brownfield projects across the country. Basically, what the government has done is put a roadmap for the next 5 years of all the infrastructure projects which are contemplated in the country, so that investors can look at it and plan way ahead. Significantly, we've got the National Monetization Pipeline, which is going to pick up projects which are already developed by the government. The idea is that they're going to monetize them, and the money from those monetized projects is going to be used to develop future greenfield projects. So basically, the government is going to take the risk in developing greenfield projects and attract private investment in projects which are stabilized and going to hand it over to the private entrepreneurs. Then we've got the National Hydrogen Mission, which is launched in 2021, and it's targeted primarily towards meeting climate targets and making India a green hydrogen, green ammonia country. However, given the current geopolitical circumstances in Europe, we are seeing a lot of potential in growth for green hydrogen, which I'm going to touch upon in the later slides. In terms of the renewable energy sector, broadly speaking, surprising to note, we are ranked third in renewable energy country attractive index in the world. We have an ambitious expansion plan to expand renewable energy capacity from 175 gigawatts by the end of 2022 to 500 gigawatts by 2030. Let me just repeat that. We're talking about literally expanding and tripling the capacity in the next 8 years from 175 gigawatts to 500 gigawatts, which is a very huge number. India's installed renewable capacity has increased 396%, that's approximately 400% in the last 8.5 years, and stands at 165, almost 166 gigawatts as of now. And the year is still to end, so hopefully we will reach the 175 gigawatt target. And is about 40% of the total country installed capacity. So we are already at a renewable energy mark of 40% of the total power which we consume. And we are expected to obviously surpass the 50% mark in the years to come. India has the fourth largest installed capacity of wind power in the world, and is the third largest in new solar capacity. There are 59 solar parks with aggregate capacity of 40 gigawatt in India. Offshore wind energy is 30 gigawatts, and there are 3 new potential wind energy sites being identified. So a total of 431 solar, wind and hydro projects, 28 are private projects and 403 are government projects, have been identified by the government with a potential investment of approximately $182 billion. Moving ahead, The broad overview of the regulatory framework governing renewable energy is as follows. So we've got renewable energy, which is governed primarily by the Electricity Act 2003, Tariff Policy of 2016, rules and guidelines issued by the central government, regulations of the electricity regulatory commissions. We both have state and central commissions, and state policies. So the regulators include electricity regulatory commissions at both the central and the state levels, with appellate tribunal for electricity, wherein the appeal lies from the state and the central electricity regulatory commission. And we also have a central electricity authority, which sets the technical standards for generation and transmission of power. In terms of regulation and licensing, significant to note that generation of electricity is a de-licensed and not, it's free for anyone to come and generate electricity in India. There's no license for sale. However, transmission, distribution and trading business requires licensing. In terms of tariff determination, there's broadly two methods to determine tariff for sale of power. Either you go to a regulatory agency and you do tariff determination, or you follow a very transparent competitive bidding process. Most players prefer the competitive bidding process, wherein distribution companies solicit sale of power to them through a transparent competitive bidding mechanism, and people bid for the same and they discover the price at which they would want to supply power. So that's how the tariff gets determined, and whatever is the tariff determined in the bidding process, the regulator blesses the same. In terms of the regulatory regime in the renewable energy sector, we've got open access for consumers, and this is a pretty significant step because as a consumer, you could purchase renewable energy from any consumer. And what the government has done is to further promote green energy projects, the Ministry of Power has reduced the open access transmission limit from present minimum of 1 megawatt to 100 kilowatt, which basically means that even smaller consumers can access, can have open access and purchase power from whichever producer they wish to procure power from. Apart from that, you can also do banking of power and net metering. What it means is that if you are not consuming that much of power, you can bank it with the distribution companies and take it later. And what net metering means is that you could be a producer who has, for example, a rooftop solar and consuming power as well. And if in the months that you are generating and consuming, you only have to pay the difference and not what you purchase from the distribution companies. Moving on and getting into the policy initiatives to drive green energy investment. So we've got a production-linked incentive scheme, wherein the government has approved a PLI scheme of INR $195 billion for manufacturing high-efficiency solar modules and enhancing export of modules. So what the government is wanting to do is reduce the import of modules, solar modules, and promote setting up of industry which can set up domestic manufacturing of solar modules. It is anticipated that an investment of INR $940 billion would go into this, leading to a capacity generation of 65 gigawatts of plant fitted with homegrown solar equipment. Also, there are green-based, generation-based incentive schemes, which entitle generators to monetary incentive for each unit of electricity that they generate from the grid for the first 10 years of operation. There's accelerated depreciation benefit to the generators at a much higher rate of depreciation than given to general fixed assets. And lastly, there is a must-run status wherein if you are a wind or a solar plant generator, then you don't have to back down in case there is a congestion in the grid infrastructure, and necessarily you would be giving priority in terms of power offtake. What the government has also done recently is we've got incentives to drive green energy investment. So you've got introduction of renewable energy certificates. This is intended to promote renewable energy, but also to facilitate compliance of renewable purchase obligations. Each distribution company has an obligation to purchase certain bouquet of power from renewable sources. And if it's unable to do that, it can satisfy that by purchasing these renewable purchase obligations. So if I'm a renewable power generator, then I can sell off some of the renewable energy certificate and generate additional revenue. There is a removal of surcharge which was levied on different class of consumers to whom open access was provided. This is not levied on captive consumers as long as they're consuming from renewable energy. There is also waiver of interstate transmission charges if you are doing transmission of green energy, and incentivizing state policies which include benefits such as easier land acquisitions, preferred allotment. So what states are doing is they're setting up literally green energy generation farms wherein the state will acquire land, designate projects wherein solar parks can be set up, and then invite private investment for the same. Moving on to emerging green resources, the way ahead. Hydrogen is a big area where we see a lot of potential growth in India. Potentially, hydrogen can use the existing natural gas pipeline network, and it can also be compressed into a fuel tank and used to power cars and buses. India is slated to produce 5 metric tons of green hydrogen by 2030, investment of around $8 billion by 2030. India will require at least 50 gigawatts of electrolyzers to ramp up hydrogen production. We are contemplating most of the green hydrogen to be produced from solar power plants. So the power generated from solar power plants would be run through electrolyzers to convert water into hydrogen and oxygen. Some of the benefits of Green Hydrogen Policy 2022 include that the green ammonia or green hydrogen manufacturers may purchase renewable power from power exchanges or set up renewable power capacity themselves or through any other developer, and they can purchase this from anywhere in the country. The green hydrogen or green ammonia manufacturers and their preferred renewable energy plants shall be given connectivity to the grid on a priority basis to avoid any procedure delay. We are anticipating that India would probably be exporting green ammonia to Europe for meeting the fuel and the power needs of Europe, and that this occasion has arisen because of the geopolitical situation in Europe. And I think Europe really is looking at reducing dependence on Russian oil and gas, and I think this would be a good way. So we are expecting, as we speak, a lot of projects to come on the west coast of India, wherein green ammonia would be manufactured and exported to Europe for further conversion to hydrogen and usage thereof. Getting into the key benefits under the Green Hydrogen Policy of 2022. So the green hydrogen and green ammonia manufacturers can bank unaccounted renewable power up to 30 days with the DISCOMs and take it back whenever they require it. DISCOMs can procure and supply renewable energy to green hydrogen, green ammonia manufacturers as well at concession rates. The green ammonia manufacturers are allowed to set up bunkers in ports for storage and export of green ammonia. The land for the same are to be provided by the existing port authorities at applicable rates. Green hydrogen and green ammonia manufacturers shall be granted open access. Renewable energy consumed by the producers in excess of their renewable purchase obligations will accrue to the credit of the local DISCOMs. So there's a benefit on local DISCOMs to supply them. The manufacturers will be exempt for 25 years, which is very significant, from paying interstate transmission charges on projects that are commissioned by 30th June 2025. And a single portal has been set up by MNRE to enable statutory clearances in a time-bound manner for these projects. One more new area that we are seeing in terms of renewable energy is offshore wind energy. Government plans to produce almost 30 gigawatts of offshore wind energy by 2030 and 140 gigawatts by 2050, mainly in the state of Gujarat and Tamil Nadu. India has huge potential to develop offshore wind farms given its 7,600 kilometer long coastline. Our first offshore wind farm is planned along Gujarat coastline, and it's a 1,000 megawatt project which is financed by European Commission. The Ministry of Power's policy on offshore wind energy involves awarding bids of 2 gigawatts each of wind power projects in Gujarat and Tamil Nadu. It is anticipated that Tamil Nadu would lease out part of the coastlines on a bidding basis, following which the power producers can set up their plants and sell directly to any consumer that they want. Gujarat is going the way of floating wind power projects, and it will be preceded by wind survey by potential bidders and then setting up of wind farms in the country. I'm going to move now to the oil and gas sector. We have a huge demand for energy, and it can't be met unless or until this oil and gas sector's share in the same. Just a broad overview of the oil and gas consumption in India. India is the world's third largest oil importing and consuming nation, only behind US and China. India is a key refining hub and the largest exporter of petroleum products in Asia. It has 23 refineries and plans to grow its refining capacity to 400 million tons per annum by 2025. We also aim to increase our share of natural gas in the energy basket from current 6.7% to 15% by 2030. Our oil demand is slated to rise from 4.7 million barrels per day in 2021 to 6.7 million barrels per day by 2030 and 7.4 million barrels by 2040. Significant to note here also, which is not there on the slide, is that what India is also trying to do is do ethanol blending in petrol. And the government currently has an aim to target 10% of ethanol blending in petrol, which is supposed to increase to 20% and then to increase at 30%. And the ethanol is mainly produced from agricultural producers, which is basically sugarcane, molasses, and grain-based plants, which is a good way to reduce oil dependency and reduce the import bill. So oil imports are nonetheless slated to double between 2021 and 2015 because of limited oil and natural gas resources availability in the country. This is a broad overview of the regulations governing the oil and gas sector. We have a regulator in the sector, which is the Petroleum and Natural Gas Regulatory Board, that has the power to regulate refining, processing, storage, transporting, marketing, and sale of petroleum and petroleum products and natural gas. We've got the Petroleum Act, which consolidates the laws related to import, transportation, storage, production, refining, and blending of petroleum. We've got the laws relating to regulation and development, which provides for regulation of oil fields and development of mineral resources in India and mining leases in India. We've also got the Territorial Waters, Continental Shelf, and Exclusive Economic Zone and Maritime Zone Act, which sets out the provisions for semi-government to explore and exploit natural resources in the Continental Shelf and Exclusive Economic Zone of India. India is significantly, has a very significant natural gas pipeline network, and it is fed by a good LNG infrastructure around the country. There is no limitation on private ownership of natural gas pipeline transportation. The PNGRB is currently exercising jurisdiction on the conversion of dedicated pipelines to common or contract carriers, and in the future, you'll probably have dedicated pipelines being converted into common or contract carriers, which will see a lot of participation by various players in the sector. They've recently amended regulations dealing with natural gas pipeline, tariff, authorization, and capacity. And we're going to move towards a unified tariff regime by financial year 23-24, which would really fast track the laying of pipelines and related infrastructure. As I said, we have 6 operational LNG terminals in the country, and another 6 are under development right now. Right now, LNG terminals are completely free of regulation, but PNGRB does have the jurisdiction to get into these and regulate the same. So soon, in around 2 or 3 years' time, we'll have 12 LNG terminals for importing LNG into the country. what we have is priority in gas allocation. So what the government is doing, MOPNG, which is the Ministry of Petroleum and Natural Gases, has said that we need to elevate natural gas from industry to city gas distribution. City gas distribution is a big business in the country. There is a exclusivity for setting up infrastructure, which is laying, building, or expanding the CGD network. Normally, it's a concession given for 25 years. It is also extendable for another 10 years' time. There's marketing exclusivity for the person who's setting up that infrastructure, and that exclusivity is either 3 years or 5 years or 8 years, depending on what authorization and concession you receive. Post that, the infrastructure is declared as a common carrier, wherein you can sell and others can also sell using that network. So once it is declared as a common carrier, any developer will have open access in that network to supply gas to end customers or any other third party. The successful bidders are required to achieve year-wise work program, which is anywhere between 8 to 10 years in the 25 years in which you're supposed to set that up. We've got a gas exchange which is set up by PNGRB in 2020, and right now there is a mechanism that 10% of the gas in the country needs to be sold through the exchange. We are anticipating that going forward, that will not be the case as the market matures and the trading matures on the exchange. This is a very good mechanism because obviously there is then a price discovery which is happening of the gas on the exchange. And the initiative has been taken by the PNGRB and it's a welcome. We've also got the transport system operator, which is an independent body being set up as a regulatory agency now to ensure that the gas grid, the capacity booking, control over it can be regulated, because a lot of oil and gas, national oil and gas companies are also players in this. That's my presentation for today. Thank you. If there are any questions, happy to address them later on. Thank you.
Thank you very much, sir. Next, I would like to request Mr. Yosei Koyama, Head of Japan Desk, partner Mori Hamada Nakamoto, to give a presentation on key aspects of the Indian Party. 続きまして、森浜田松本法律事務所弁護士インドデスクヘッド小山洋平様よりインド当事者との答弁開始のポイントについて講演いただきます。よろしくお願いいたします。
ありがとうございます。I would like to thank you, His Excellency Mr. C.B. George and Mayank Josh and Akshay Goyal for preparing this seminar and giving us this opportunity. And I hope today's session will be meaningful for our audience, and then hope the investment in India will increase. So let me speak in Japanese for my session. 皆さんこんにちは。よろしくお願いします。森山小山でございます。本日は、私のパートは Key Aspects of Joint Venture with Indian Party ということで、私、小山と、あと後半ですね、森浜田の事務所に属しておるインド人弁護士のシュバムというものが、具体的なそのインドのプロジェクト案件ですね、エナジーセクターの案件についてご説明させていただきます。で、私のところなんですが、主に、合弁パートナーとの交渉、もしくはその合弁が発足した後の、交通のようなものを紹介する予定でございます。で、なぜそういうものを扱うかといいますと、先ほどご紹介ありましたように、ご説明ありましたように、インドのエナジーセクターのプロジェクト、いろんなレギュレーションなり、州の法制なり、インセンティブスキームなり、そういうリーガルなもの、もしくは契約のタームというのはですね、我々、弁護士が得意とするところですけれども、最終的にその案件をまとめるっていうのは当事者様であるわけでして、私、日本企業を代理することが多く、相手方、インド企業、インドのパートナー、 であることが多いんですけれども、見ておりますと、なかなか交渉ということに来ると、日本のチームといいますか、日本の企業の担当者さんは、必ずしもうまくいかないこともあるというところで、かつ契約書が締結されてもですね、実行後のオペレーションの時に問題が生じるとか、そういった事項が、インド以外の国とインドを比べると、インドの場合、多く生じるのかなというふうに思いまして、そのようなテーマで少しお話しさせていただければと思います。まずは合弁対合弁、単独進出対合弁進出ということで、スライド3ページお願いします。3ページですね。単独進出対合弁進出というところで書かせていただいていますけれども、これ一般論でございます。で、私どもがいろんなこういう団体をサポートさせていただく中で、単独進出を選択する場合というのは、ターゲット顧客がすでに決まっている場合ということで、日本からインドに進出するんだけれども、すでに例えば日本のビジネスパートナーのお客さんがインドに進出するので、それに伴って進出するとかですね、もしくはすでに販売ルートは確保しているんだけれども、その原価を下げるためにインドで作ると、そのために製造網を構築すると、インドにですね、そういうような場合というのは単独で進出することが多いということに対して、今回のエナジーセクターのようにですね、よく合弁進出、日本企業にとってはなかなか単独でやりきるというのは難しいと、外資規制上、そういう制約がなくてもですね、難しいと。というのは、例えばいろんな発電所とかですね、そういうプロジェクトを作る際に、例えば土地が必要になりますと。で土地で申しますと、インドの土地の制度は日本と大きく違っておりまして、日本だと登記簿がですね、所有者は誰かですとか、担保権者は誰かというようなところをきちんと書いたその一覧表のような登記簿と言われるものがあるわけですけれども、インドの場合、そういう制度にはなっていなくてですね、土地の所有者、もしくはから買おうとする場合、もしくはリースする土地でも、権利関係を調べようと、そういう場合にですね、土地に関する登記簿がないので、その土地に関して過去取引された売買契約ですとか、担保権の設定契約ですとか、場合によっては賃貸借契約とか、そういうものを一個一個精査していかないといけないと。いうことで、かつそれがですね、州によって例えば言語も異なるわけですので、場合によっては現地の用語でその書類を見ないといけないと。そうなるとですね、なかなか日本の企業単独でやりきるのは難しいと。でかつ、発電所を作ろうという場合に、州政府との交渉ですとか、もしくは許認可を取ろうとする場合に、なかなか自身でやるというのは難しいということで、通常ですね、合弁パートナーを伴って、彼らのノウハウでやるということが多いというふうに理解しております。次のスライドをお願いします。そこで合弁パートナーとの交渉戦略というところが必要になってくるわけですけれども、次お願いします。そうですね。インド企業、いろいろございます。私どもですね、よく製造業ですとかサービス業ですとか、そういうセクターのサポートをさせていただくことが多くて、今日は一緒にセミナー共催させていただきます。シャルドラマンチャンネルの、先生方とご一緒することも多いんですけれども、インド人の場合ですね、インド企業の場合ですね、それは相手方が、上場企業であったり、中小企業であったり、多くあるのがファミリー企業と言われるところですね、いわゆる財閥と言われる、会社がインドには多いようでございますので、そういうところと交渉していかないといけないというときに、まずキーパーソンを把握するというふうに書かせていただいてますけれども、よくインド案件であるのが、交渉担当者と、交渉を順調にしていたと、もしくは少なくとも交渉を順調にしていたと思っていたという場合に、交渉担当者レベルでですね、合意できて、で我々、日本の企業の、上司からすると、その交渉の経緯というのは、社内でも共有して、場合によっては承認を得て、進めるということなんですけれども、相手方の交渉担当者の方でですね、実は実質的な決定権を持ってないですとか、エナジーセクターではそれほどないかもしれないですけれども、相手方が数ファミリーに分かれていた場合に、あるファミリーの担当者とは合意できたものの、他のファミリーとは合意できてないとか、もしくはその会社が兄弟もしくはファミリーによって 所有されている場合に、あるその、担当者は問題ないんだけれども、その家族についてはですね、合意されてないとかですね、結構そういうことが多いんですね。なので、その交渉する際に、相手とその企業のパートナーの、どこの部署、もしくはどの人物がキーパーソンなのか。で、今、相手方と合意している、もしくは交渉している事項というのは、そこまで共有された上でのことなのか、そうではなく、窓口の担当者だけが、交渉していることなのかというところを常に見極めながらですね、やっていかないと、最後の最後でどんでん返しを食らわされたり、もしくは、よくあるのが、こちらの、社内承認とか進んだ後に、最後にもう引けなくなったときにですね、追加の要請とか、最後にねじ込まれると。でこちらとして、日本の企業の皆さんは案件をやることが必須の状況に陥った場合に、その不合理な状況を飲まされるとかですね、結構そういう不幸な事例というのを拝見することが多いです。なので、そういう交渉担当者の見極めというのが非常に重要だというふうに思っております。で他方で日本の側でもですね、これも同じことを言えるわけですけれども、よくインド人の交渉の相手方から言われることが、例えばその社内の経営会議なり取締会なり、我々からすると当然の倫理の仕組みではありますけれども、そのためにですね、例えばサイニング日の1ヶ月ぐらい前からですね、もうほぼほぼ合意された条件が出来上がっていないといけないと。で例えば取締役会の資料であれば1週間前には固まっていないといけないということを言うと、びっくりされると言いますか、なかなかそういうカルチャーではないと。インドの、進め方といいますか、そういうものは、サイニング日があれば、それまでに文言が詰まればいいんだということで、最後のそうですね、3日ぐらいになってようやく交渉に火がつくと。でそうすると、オーバーナイトで交渉したりということがありますけれども、その交渉の進め方がですね、なんとか間に合わす、タイプのインド企業、場合によってはそれインド企業の姿勢と、順序立ててですね、いろんな階層の、合意をコンセンサスを取っていかないといけない日本企業と、進め方が違うということがありますので、そういうところでこちらもですね、きちんと、進め方っていうのは日本企業こういうものなんだということをきちんと言っていかないといけないというところでございます。次お願いします。あと、交渉の進め方ですね。これ、こだわりのポイント、双方の譲れないポイントを把握するということで、タイムシートというふうに書かせていただいておりますけれども、よく私ども欧米の案件とか、インドの案件もさせていただきますけれども、例えば、10個ほどですね、その交渉しないといけない論点があるとするとですね、日本企業同士ですとか、もしくは欧米企業との交渉において、例えば2時間で10個だとすると、大体タイムアロケーションをしてですね、一つのものが合意に至らなくても次に行こうというような進め方をするわけですけれども、事実としてですね、インド人の皆様方、結構交渉力が強いということで、結構一つ目のイシューに到着してですね、それで1時間ほど、もしくは1時間半ほど使ってしまうとか、そういうことが結構あるんですね。なので、それになってしまうと、せっかく、日本に来て、もしくはインドに行って交渉したにもかかわらず、全くつまらないということがありますので、双方のですね、細かいところはさておきですね、譲れないポイントは何なのか、双方にとってこのプロジェクトをする意味っていうのはどこなのかということを最初に押さえた上で、いきなり契約書のドラフトを作るというよりかは、タームシートみたいなものをですね、作って、それ、法的拘束力がないものであっても、例えば、それについて署名するということもいいですし、署名せずに、それで大体まとまったら次に、最終契約を作ろうということでもいいんですけれども、そういうような進め方をすることが重要ということが言えると思います。でこちらのスライドの下半分ですね、書かせていただいているところは、その自社が交渉力があるフェーズというのはどこなのかということを気にしないといけないと。で例えば、これもよくあるんですけれども、交渉の際によくいろんなこちらの言うことを聞いてくれたから、合弁関係が進んだ後も、こちらの言うことを聞いてくれるだろうというふうに思っていると、そこは手のひら返しで、案件が一度クローズして、合弁関係が進むと、何ももう向こうのというのはインド側の勝手に進められてしまうということが結構あるんですね。でそうならないよう、それはなぜかというと、そのいわゆる交渉力といいますか、バーゲニングパワーというのがどこであるかというふうに言いますと、やっぱり契約締結前なわけですね。 場合によってはインドのパートナーはこちらの技術が欲しかったりですとか、資金力が欲しかったりですとか、いろんな理由があって欧米パートナーを組むわけですし、こちらインド側のスキルですね、その政府との交渉スキルとか、そういうノウハウが必要で来るわけですけれども、そういうところが交渉している、契約の締結前っていうのが一番交渉力があるフェーズなわけですので、そこで例えば将来のプロジェクトにおいて、州政府との許認可が取れているのかどうか、もしくは土地のリース契約がきちんと締結できているのか、その手数料ですね、経済条件が合意できているのかとかですね、そういうものをきちんと詰まったこちらの要求するような水準で締結されたのを見てからこちらも本契約に行くというような進め方をしなければですね、その交渉力がなくなってからそういうものをこちらの要求通りに通そうとするとなかなか難しいということですので、インド案件においては特に注意を要するということでございます。次のスライドお願いします。で、そうですね、適切なパートナーであるかの見極め、これも似たような話ではあるんですけれども、やはり契約交渉ですね、その間に当然事業計画について意見を交換したり、将来のプラン、事業プランについてですね、交渉したりとかっていうことがあると思いますけれども、その際に、この相手方の担当者、もしくは企業と信頼関係を築いて、一大プロジェクトである、そういうエナジーのプロジェクトを進められるのかというところを見極める必要があるというふうに思っております。で、先ほど申し上げたような許認可が取れているのか、もしくはリース契約がまとまったのか、もしくは土地、建てようとしている土地について、先ほど冒頭に申し上げた土地のデューデリジェンスをした際に見つかった問題、そういう問題が解決しているのかどうか、そういうところをですね、見て、万が一、これはちょっと難しいんじゃないかというときはですね、これはぜひ引き返す勇気の必要ということで書いておりますけれども、実際、私どもの案件でも、エナジーセクターではないんですが、合弁パートナーのインド企業と、やろうということで、法務、財務、環境のデューデリジェンスをした後に、少しビジネスの観点で、何かつじつまが合わないような説明であったりですとか、その業界の噂が、ちょっとそのパートナーのその業界における噂が良くないような、そういうところが漏れ聞こえてきたことがありまして、ただそれがもう締結の1ヶ月前とかですね、もう相当費用と時間をかけて交渉した後だったんですね。その時に我々結構強く、こういう問題が山積しているので、もちろん契約書上合意すれば何でも法的なプロテクションがかけますけれども、それを実際、権利執行するっていうのは、後ほどプレゼンテーションがあるかもしれないですけれども、なかなかインド企業との紛争っていうのは難しいところがありますので、今、すぐにちょっと焦って締結する、フェーズではないんじゃないかというふうに申し上げたんですけれども、なんとかですね、その追加のプロテクション防御策を契約書に盛り込んで案件を実行したところ、1年、2年経たずにですね、そういうところの問題が顕在化して、残念な結果を迎えてしまったという案件が実際ございました。なので、比較的拝見しておると、日本の企業様の進め方のスタイルというのは、ひとたび案件やると決めたら、最後までやらねばならないというようなところが見え隠れ、私どもから拝見しているとあるんですけれども、なかなかそういうスタンスだと結論ありきで、うまくいかないので、きちんとそういう引き返す勇気も必要だということで書かせていただきました。次お願いします。で、交渉のスタンスですね。基本的に、インド人の弁護士もしくはプロモーターもしくはそのビジネスパートナーの方々というのは交渉は上手です。で、会議とかになると、日本側が比較的2割ぐらい話して、インド側が7、8割話すみたいな、そういうところも多くてですね、そこをなんとか交互に私どもの方で戻すんですけれども、そういう交渉の時にですね、100% の M&A と合弁契約の場合、交渉のスタンスも違うかなというふうに思っていまして、100% の M&A、つまりその既存のオペレーションを完全にこちらが買い取ると、で、そのインド企業の売り主になるインド企業とはもう付き合いませんというような場合には、ある程度ハードな交渉もいいかなというふうに思いますけれども、合弁パートナーになるというような、株主間契約ですとか、ジョイントベンチャー契約というものを締結する場合にはですね、 何かこう交渉で勝ち切ればいい、少しでもいい条件を勝ち取り切ればいいというわけではなくて、相手がある話なので、こちらが要求することは裏返して相手も要求したいということを踏まえて、ある程度信頼関係をベースに今後、オペレーションをするというのがメインなので、それを見据えた交渉が必要だということでございます。で、そういう意味で、この、案件で経験もあったんですけれども、相手に無理にですね、押し付けて、なんとか勝ち取った、ちょっと相手が無理をしたような契約条件っていうのは、契約上はですね、合意されてもですね、いざその実行フェーズに移った段階で、相手方がそれをこう履行できないような、もしくは後で変更を求めてくるような、そういう場面も結構ございましたので、交渉スタンスとして、契約上勝ち取ればいいというよりかは、相手方が本当に無理なく、もしくは少し無理をして、履行できるのか、契約書に通り守れるのかというような内容でまとめる必要があるということに注意をするということになります。以上が契約交渉のフェーズということで、日本の企業の皆様、インド側のビジネスパートナーの方が結構交渉力というのが強いので、こういうところを注意する必要があるかなというふうに、こちらから拝見していて思うことを申し上げました。で次ですね、ジョイントパートナーとの合弁契約ということでご説明させていただこうと思いますけれども、いよいよ合弁契約、ジョイントベンチャーアグリーメントですとか、シェアホルダーズアグリーメント、スライドを次お願いします。10ページですね。はい、さらに次お願いします。こちらですね。ジョイントベンチャーアグリーメントですとか、シェアホルダーズアグリーメントというものを締結するわけですけれども、エナジーセクターでもあってもですね、合弁契約ということは同じですので、製造業ですとか、サービス業のジョイントベンチャーと、項目としては似ていると思います。具体的にはここに書かせていただいた通りなんですけれども、会社設立に関する事項、これ新規設立の場合であれば書きますけれども、主にはガバナンスですね。総会の運営方針ですとか、役員の選任ですとか、場合によってはその拒否権自由ということで、マジョリティの株主とマイノリティの株主がいる場合に、マイノリティの株主の方が、その合弁の運営について拒否する権利と。これは例えば莫大なその投資をすると、何かの発電所を作ると、もしくはそれをさらに追加投資していくという、多大な金額がかかるときに、マイノリティ側の承認を得てから進めるというような形で拒否権を持つということで、ガバナンスに関与するということがございます。あと、新株引受権、各株主が出資比率を維持できる権利と。こちらが例えばマイノリティで、参加する、プロジェクトの場合に、数の原理でですね、向こう側に、マジョリティ側にどんどん新株を発行されて、こちらの持ち分がどんどん大流通すると、下がってしまうという場合には、当初のスタンスというのを維持できなくなるので、引受権を設けるということがございます。次、株式譲渡制限ですね。なかなかこれで合弁のオペレーションにおいてトリガーされるということは多くはないんですけれども、双方株式を持っていますので、それをそもそも第三者に譲渡していいのか、ダメなのか、もしくは譲渡するとしても、まずは相手方にその譲渡をさせるように求める権利を与えるのかとかですね。もしくはその相手方が売る場合に、自分もくっついていくのか、もしくは相手方からすると、その小さいポーションのものを一緒に売らせるとかですね、いろんなそういう株式の譲渡という場面を見つけたときに、関係してくる譲渡制限の規定というのがございます。そういったものをですね、きちんと作り込んでいって、合弁規約というのは作成されるということでございます。いくつか個別の条項についてご説明させていただきたいと思いますけれども、次のスライドで1ページでございます。で、会社設立の定款ということで、こちら少し技術的なところなんですけれども、インドの会社の定款ですね、ちょっと日本の会社の定款とはイメージが違いまして、かなり分厚いです。で、目的事項とか会社の基本的事項が書かれているところと、あと、それとは別に、インドのガバナンス、先ほど申し上げたようなガバナンスが書かれている商品に分かれておりまして、後者はですね、その、いわゆる株主間契約など合弁契約の、条項がそのままコピー&ペーストされるような形で、書くことによって、株主間契約、基本的に株主間の契約ですけれども、それが定款に盛り込まれることによって、会社ですね、合弁会社も拘束されるというような仕組みになってまいります。で、 そういうところで、仮に株主間契約と定価の内容が不一致であると、ガバナンスがどちらを尊重すべきかというところが、紛争が生じますので、そこの一致ということをきちんと見る必要があるというのが上半分ですね。で下半分、ガバナンス、日本の場合、例えば1人株主も認められますが、インドの場合は少なくとも2人必要ですとか、特別決議が 75% であるとかですね、そういうことを見据えたパーセンテージを考えないといけないと。で、そういうところはガバナンスで、知識としてあるんですけれども、3つ目の非公式な会議体を通じたコミュニケーションの有料というふうに書かせていただきましたけれども、これもまた契約書から少し離れた話になるんですけれども、うまく合弁事業がいって、でかつ、その収益を上げている会社、それはインド側のみが収益を上げるんじゃなくて、日本側も収益を上げている、満足する合弁のオペレーションを続けている会社さんというのは、かなり密にそのインド側パートナーと、コミュニケーションをしている印象がございます。でそのコミュニケーションというのは、必ずしも、定例の取締役会である必要はなくて、マンスリーの非公式な、もう少し部長級も含めたコミュニケーションでもいいと思うんですけれども、そういうことを通じてですね、きちんとウォッチしていると。で、日々のそういう、細かいイシューが生じたときに共有して、イシューが大きくならないうちに解決していくと。そういうことを密にコミュニケーションしている会社さんというのが本当にうまくいっているなという印象がございますので、もちろん株主間契約を交渉で勝ち切るというのも、ある程度重要なんですけれども、こういうコミュニケーションが、より実務の運営という意味では重要だということで理解しております。次お願いします。で、新株引受権ですね。これは先ほど申し上げた通りですけれども、下半分の株式譲渡制限というところで、例えばライツ・オブ・ファースト・リフューザルというもので、先外権と日本語で言うものがございますが、例えばこういうものというのは、相手方が、もしくは自らが第三者に株式を譲渡したいと、エグジットしたいと。いうときに、まず相手方ですね、合弁パートナーの相手方に先に買う権利を与えると、いうことでございます。で、そうすることによって、実質上、その株式の処分が困難になる効果があるということでございますが、これは具体的に申し上げますと、その自ら株式を譲渡する場合に、自由に交渉できずに、交渉してもいいんだけれども、売る前にですね、合弁パートナーに買うチャンスを与えないといけない。ということになると、そういう前提で交渉に乗ってくれる第三者ってなかなかいないわけですよね。で、そういうふうにして、事実上、この株式の処分で難しくなる仕組みで、当然、相手方にチャンスを与えた後に、そこで折り合わなかったら、同等の条件で第三者に売るっていうのは可能なんですけれども、そういう、ことを入れるとですね、どういう効果が生じるのか、その株式譲渡が難しくなるという効果なんですけれども、そういうところを見据えながら、この条文を置くのかどうかというところを検討していかないといけないと。で、例えばその、一括売却請求とか売却参加権ということで、相手方が売る場合にですね、一緒に売ります、もしくは自分が売る場合に相手方のも一緒に売らせろとかですね、いろいろアレンジは合意次第あるんですけれども、こういうのもですね、株主間契約でよく見られる状況だから当然に置くということではなくて、そのプロジェクトがどういうことになった場合に、例えば、一定の成果が下りなかった場合には、エグジットできるとかですね、そのリース契約が断念された場合には、エグジットできるとか、エグジットする手段として、どういうもので、処理するかというようなところの何が将来起きうるかで、それが起きたときにどういうプロテクションが必要かということで初めて必要であれば規定するということで、何か株主間契約のひながらに入っているから規定するというものではないということで、考える必要がございます。次お願いします。で、デッドロックと言われるものですね。これ、上半分がデッドロック、下半分が契約違反時のフットコールオプションというのを書かせていただいてますけれども、デッドロックっていうのは、いわゆる、意見の不一致でございます。で、どちらの、合弁パートナーが契約違反をしたわけではなくて、単純に意見が合致しないと。今、もしくは来年にこれだけの規模の設備投資をするかどうか、これ、一種の判断なわけですけれども、する、しないっていうのは別に契約違反ではなくて、ディシジョンメイキングの問題ですと。そういう考えが合わないとですね、なかなか一緒に合弁パートナーで事業をすることが難しくなるので、契約の締結前に、事業計画っていうのはある程度策定するわけですけれども、 それ以外の方針で揉めた場合には、やはり欧米パートナーを解消する必要があるということになっていまして、デッドロックの処理方法、もしくは契約違反時のプットコールオプション、株式の売買をするやり取りの規定というのは、日本の株主関係であっても、グローバルなものであっても、どちらもよく見られるものですが、インドの場合ですね、プライシングガイドラインというものがございまして、小さい字で下の方に書いておりますけれども、外資規制の一つでございまして、株式を売買する場合に、居住者同士とか非居住者同士であれば問題ないんですが、居住者、インド企業ですね、もしくはインドの個人の方と非居住者、日本企業を含む外国企業が取引する場合ですね、FMV といわれるフェアマーケットバリューというものを算定するわけですけれども、そのフェアマーケットバリューが算定されたときに、非居住者から居住者に売る場合にはですね、居住者が不利にならないようにフェアマーケットバリュー以下でないといけないとか、逆に居住者、インド側から日本に売る場合というのは、またインド側が不利にならないようにフェアマーケットバリュー以上でないといけないと。そういうことでフェアマーケットバリューで売買することが一般的なんですが、そういうことがよくあるわけです。なので、そういう規定との関係で、この、プットオプションなりコールオプションというのを考えていくとですね、少し込み入った話になりますが、契約違反時のプットオプション、コールオプションというときに、この2つ目ですね、一般的に見られる FMV の 120% の価格でのプットオプション、80% でのコールオプションが機能しない可能性がございます。これは何かと言いますと、契約違反をどちらかがした場面ですので、その違反当事者の株を召し上げる、もしくは自分の株式を売りつけるということが、契約違反の解消方法としてあるわけですけれども、そこに制裁金含みでですね、相手方がに株式を売りつけるときには、フェアマーケットバリューではなくて、その 120% の価格で売るとかですね、もしくは買い上げるときに、ディスカウントの価格、例えば 80% の価格で買うとかですね、そういうことをしたいと、実際そういうアレンジが一般的なんですが、先ほど申し上げた価格規制によって、それがそのまま機能はしない可能性があるということでございます。で後のセッションでディスピュートソリューションの解説あると思いますが、そこでもタタドコモの事例とかを扱うと思いますが、タタドコモで新聞でも報道されていたものも、このプライシングガイドラインが少しネックとなって紛争になってしまった、すぐには解決しなかったということですので、こういうインド特有のレギュレーションというのは注意が必要ということでございます。次お願いします。で情報アクセス権ですね。これは形式的な情報アクセス権ということになるんですけれども、そういうのを別に取締役を派遣しているんであれば、そういう別にアクセス権なんてわざわざ提示しなくても、その取締役を通じてもらえばいいじゃないかということなんですけれども、ページは確かにあまり意味のない規定かもしれません。ただ、有事になったときに、例えば相手方と解消したいなというときには、相手方の契約違反事由というのをいくつか集めてですね、これでプットオプションを行使する、コールオプションを行使するっていうふうに結びつけていくわけですけれども、大体そうなったらですね、なかなかコミュニケーションもない、情報も入ってこないというような状況になってまして、この情報アクセス権、何かあったときに、例えば報告するような義務なりを課していると、その違反ということが言えたりしますし、この情報アクセス権ということも、日々のモニターということでは、かなり重要ということになってきますので、本当に必要な情報が、こちらから能動的に調べなくても入ってくるような、そういう仕組みをすることによって、事前に紛争を回避することができるということでございます。最後にですね、以上が株主関係約なんですが、最後に一つのスライドだけ、15ページ、16ページお願いします。合弁事業の運営上の留意点ということで、1点だけですけれども、先ほどの繰り返しですが、前半はですね、こちらがマイノリティの株主の場合、その契約交渉中はバーゲンパワーがありますが、いざその運営が始まると、場合によっては、無視されて、インド側で、暴走っていうんですかね、勝手に判断される可能性があるので、きちんと日々の業務に目を光らせる必要があるというところが、1点目。そして2つ目ですね。日本ではなかなか、最近はちょっとメディア探してますけれども、こういう、インフルエンス圏で、贈賄とかっていうことはなかなかないんですが、インドの場合、だいぶクリーンアップされてきましたけれども、州レベルでは、まだそういう、ソベレンスタといいますか、贈賄の要求とかっていうのが、今日にちょっと絡んで、来る場合も、見受けられます。 例えばまあ20年、30年前であれば、そんなことあるよねと言っていた時代ももしかするとあったかもしれないんですけれども、最近、例えば日本の上場企業のいろんな不祥事とか、我々もお手伝いさせていただきますし、私もインドの成長査とかをしたことありますけれども、ひとたび小さい額でもですね、そういう贈賄の疑いがあると、日本本社主導で外部の専門家を交えて、調査するというような大規模になってきますので、ここのアンティコラプションというのは絶対に許されないと、場合によっては株主関係約にきちんと入れて、そういうことは一切しないということで、体制を組む必要があるということになってまいります。はい、じゃあ以上が私の日本語で失礼いたしましたが、スライドの説明になります。で後半、シュバムの弁護士に交代しようと思いますけれども、シュバム、can you come? シュバム、can you come? Yeah. So, シュバム弁護士ですね、外国人弁護士でございまして、MHM の弁護士でございます。で、私どもと、今、外国法人弁護士として、日米連に登録している外国人弁護士でございます。で彼の方から、具体的な事例をいくつかご紹介して、我々のパートを終えたいと思います。ありがとうございました。
Thank you very much. 皆さん、こんにちは。My name is Shubham Agarwal and I'm a foreign attorney at MHM. I'm an India qualified lawyer and I'm also registered with the Daiichi Bar Association as a foreign registered lawyer. I have more than 8 years of experience in advising on India matters. Today, I will discuss on some of the investment trends from Japan in relation to Indian energy companies. 4 trends that we have identified, and this is all identified based on press releases and media reports published by Japanese companies on their Indian investment. First, most of the transactions that we have seen has happened by way of third-party allotment. One of the possible reasons why we think this may be the option, because given that this sector is very capital intensive, the Indian target company requires capital. So that is why they would have preferred a third-party allotment transaction. Second, based on the press releases and the transaction that I'll discuss later, most of the press releases say that Japanese investors will give their technical know-how based on the investment that they've made outside India. So that would be a helpful thing for Indian target companies. Third, the role of Indian parties. Given that the expectation from the Indian party is to manage the project and get all approvals and licenses, and also negotiate with the government for power purchase agreement. This is why the role of Indian parties is very important in this kind of sector. Fourth, the preference for minority investment and the transactions that we have seen has all been to take 20-30% as minority investment and not to acquire control or majority acquisition. And 3 possible reasons why we believe that would be the case. First, as I mentioned, this requires a lot of coordination with the government authorities, and Japanese investors would want Indian parties to negotiate and get all approvals and licenses, and they wouldn't want to take those kind of operational aspects. Second, most of the renewable companies in India are loss-making now, so they wouldn't want to invest too much money in loss-making companies. Of course, depending on how it happens in the future, they may increase their stake, but now most of the transactions that we've seen are minority investment. Third, this is a relatively new sector where Japanese companies have started investing. So that may be a cautious approach that let's see how the sector evolves. Then they may consider acquiring majority stake. But as I will discuss, the 4 transactions that we've seen, they have happened in the last 3 years. So relatively, this is a new sector for Japanese companies to invest in. Next slide. Yeah, so the second slide that I will discuss is the due diligence aspect. Of course, in any transaction, there will be a due diligence. But for this sector, 3 things that we think are important would be the land and title due diligence. Given that project companies will require a lot of land for project development and setting it up, it's important to do a title diligence on the land, whether the land is part of a lease aspect or its own. Chances are that it will be on lease. So it is important to see the terms of the lease, whether it's a renewable termination right of the lessor. So land title diligence becomes an important issue in that aspect. Second is the power purchase agreement. So if the Indian company already has power purchase agreements in relation to selling their power to state-owned distribution companies, then it is important to see the terms of the PPA, whether
what is the tariff agreed in that, whether they have a unilateral right to terminate the PPA, the duration of the PPA, because this will again affect the commercial viability of the project. So this is an important thing to look for. And third is the environmental matters. So again, this is linked with the land title due diligence, whether the site project land is forming part of any forest land, or whether they have been classified as land for endangered species. Because these are long-term projects, any environmental concerns may result into litigation. So these are important things to consider as part of the title diligence. Okay, so this is the first transaction that I'll discuss. This is again a minority investment. This happened in March 2022. So Chubu Limited invested 20% shares in OMC Power. So this is again a third-party allotment. The reason I mentioned that, because Indian companies require capital for project development, this may be a reason why a minority stake was taken, and again with respect to third-party allotment. This was the first investment by Chubu Electric in India. That may also be a reason why they considered minority investment. If you see from this structure, so it was a 20% acquisition, and the transaction value was not so big. It was approximately 39 million. As part of the transaction, they appointed directors on the closing, and based on the press release given by Chubu, their contribution towards the project company would be to help them in the maintenance of power transmission and distribution business, and to of course expand the business. But as you see, the Indian partners is required to take maximum work in relation to getting approvals and for expansion. So the limitations from Japanese partners have always been to give technical know-how. Second slide. Yeah. This is the second investment that I'll talk about, and this is in relation to investment by JERA in Renew Power. It was a 10% acquisition, again by way of third-party allotment. So one interesting thing that came out from the press release was that this was the first major investment by JERA in the renewable energy space. That may also be the reason that they wanted to start with minority investment. Again, this was a third-party allotment. That means that they need capital for the development of their project. One important thing to consider is that this company, the local partner in this case, Renew, is a well-established company in India. They started their business in 2011, and based on the company's website, they have around 13.4 gigawatts of capacity, which means that even prior to JERA's investment, they had commissioned projects, which may kind of give more comfort to JERA that the entity that they're investing in had commissioned projects and are capable of executing projects. Again, the press release from JERA had mentioned that their role in relation to the transaction after investment would be to provide technical, operational, project development and management expertise. So, as I mentioned earlier, Japanese investors want minority stake and they will give their technical know-how, but they would expect the Indian partners to kind of execute and commission the project. Yeah. So, this is again a transaction where Orix acquired 22% in Greenko Energy. So this had two parts of the transaction. One was Orix already had around 873 megawatts of energy projects in India for wind and solar business, which they were managing themselves, but they sold that assets to Greenko in exchange for new shares of Greenko. So technically, Orix exited their own business, and that was sold to Greenko for which they got shares, and they also acquired some secondary purchase from the founder group. So that is why they have 22%. So this is again an example where even though it was a minority stake, but a minority stake in a large company, because the investment value for this transaction was around $960 million, which is comparatively larger than the transaction that I've discussed. Again, for Greenko is again the local partner in this. And important to note about Greenko is that it is backed by global private equity funds. So that kind of capability and funding problem is not an issue for this Indian company. And again, based on the company's website, they have around 7.5 gigawatts of installed capacity, which again shows that the Japanese investments are into companies which have already started doing business in India and have executed projects for them to invest in India. This is okay. This is a transaction which is not a minority investment but a joint venture which happened recently in 2022. In this case, Mitsui and Renew will set up a joint venture company where Mitsui will hold 49%, again not taking the majority stake, and Renew will hold 51%. So in this case, the projects have not started and will start from 2024, and the investment will be to set up and start the projects. And it is the total investment for this starting the project will be around $1.35 billion based on press release. And the capacity of this project would be 1,300 megawatts, which kind of shows that companies are investing to kind of increase solar and wind capacity in India. And the local partners are kind of taking that initiative also. Again, in this transaction, it was from the press release, it was stated that Renew will take care of all the EPC operation management of the project, whereas Mitsui will give their knowledge in relation to whatever power electric business that they have set up, that they've invested globally, and bring best practices for this investment. Okay, so this is from my part on the energy sector. Just quickly taking the last two slides. These are two books that NHM lawyers have written on India. This is on the Indian real estate business, Indian real estate law, based on our transactions that we have worked and advised on. So this is a well-detailed book in Japanese, which talks about how Indian real estate legislation works and the small nuances of it. And the slide after that captures the corporate law aspect. So that is again a book in Japanese, which talks about general corporate aspect of India. So if you require copies of this books, please you can reach out to the email address in the last slide. With this, I end my presentation.
Next, I would like to request Ms. E.T. Susan, partner, dispute resolution, Chantal Amarchan Mangaldas and Court to give a presentation on recent developments in dispute resolution system in India. 続きまして、シャルトル・アマルシャンド・マンガルダスパートナー、ディスピュート紛争解決、E.T. スーダン様より、インドにおける紛争解決システムの最新動向についてご講演いただきます。
Good evening, everyone. Thank you very much for giving us this opportunity to discuss the developments in the Indian dispute resolution sector with you. As we heard earlier this evening, India has become a hub for investments in the Asian region, and this is exactly the reason why disputes has become an extreme topic for most investors. It's very important for investors to have the surety that their investments would be safeguarded, because if there is a dispute, there must be clear rules that they can predict at the time of the investment. So just keeping that in mind, I just like to go over a few slides to give you an overview. India has jumped 79 positions from 142 to 63rd in the World Bank's Ease of Doing Business ranking 2020. You can see from the graph there that just between 2016 to 2019, the position has skyrocketed and we've jumped to position number 63. We are the first position among South Asian countries. And a lot of this, of course, has to do with the government's initiatives to put in place a single window system as far as approvals are concerned for investments into India. There has also been a marked improvement in the recovery rates for insolvency in the country. And the timelines for any insolvency process has gone down from 2.3 to 1.6 years. Again, just to give you a sense of where we are in the Global Innovation Index, India is ranked 1 in the Central and Southern Asia region today. As you all must already know, Japan is the 5th largest investor in India, with cumulative FDI inflows of 37.79 billion during the years April 2000 and June 2022. Some of the key sectors that we've also spoken about earlier are automobiles, electronics, system design, manufacturing, medical devices, consumer goods, textiles, food processing, and chemicals. India's total trade with Japan has increased to 15.3 billion in the years between 2031 and 2020 and 2021. And as historically known Japanese brands such as Suzuki, Honda, Sony, and Panasonic dominate the Indian markets and have their own success stories to tell. So I think in this context, we can look at what has caused perhaps this increase in investment from a disputes position. The Indian government has been very closely working at improving the legislative framework and has brought about various amendments to streamline litigation processes, mostly to reduce the timeline that's associated with the litigation matters. To give you a broad overview, some of the legislations that have had a drastic change in the timelines that we are seeing. The first one is the Arbitration and Conciliation Act, the Commercial Courts Act that was introduced in 2015, which is specifically set up as a specialist court for commercial matters over a certain threshold. The Specific Relief Act, which is a legislation that allows parties to obtain urgent interim relief and not wait for damages in a dispute situation. We'll talk about more of this in the later slides. And of course, the Insolvency and Bankruptcy Code, which is a consolidated code that has made sure that now there is time-bound resolution in case of insolvency of partnership firms, companies, and individuals. Now, the Arbitration Act arbitration is an area that there has been a lot of focus and development in the Indian sector. The government is constantly looking at the legislation to see what's lacking and what needs improvement. But it started with the 2015 Arbitration and Amendment Act. Obviously, the objective has been that there must be a speedy completion of arbitration proceedings. In case of domestic arbitrations, now a domestic arbitration must be concluded within a period of 12 months, which can only be extended by parties' consent by a further period of 6 months, which means within a total period of 18 months, a tribunal is mandated to complete an arbitration process. By a later amendment, this now has been amended to not apply to international commercial arbitrations because international commercial arbitrations often have complex issues and do need a little bit more time to complete over 18 months. In case the tribunal cannot complete the arbitration within a period of 18 months, the parties have to make an application before the court, and only upon satisfaction of a reasonable cause do the courts allow an extension beyond the 18-month timeline. Under the Act, there is also a scheme which we don't really see in practice too much, but technically the court will also have the power to reduce the arbitrator's fees if they feel that the arbitrator has not concluded the proceedings effectively and that the cause for delay is not reasonable. The second most important aspect of change that has come about is the restriction in the scope of court's jurisdiction. In the good old days of the pre-2015 regime, the problem that we were often seeing was that parties would have a dispute and go to arbitration, get an arbitration award, and ultimately end up litigating the issue in court because there were several levels of appeal that were allowed to our party, and the scope of interference was not clearly delineated. So, we were seeing cases that were perhaps stuck in arbitration for 6 or 7 years, and then they were stuck in courts for several years thereafter, and there was no effective relief. So, this has been a very significant change because now the legislation prescribes very limited cases in which courts can interfere. One is, of course, what we commonly call the Section 9 relief, which is an interim relief measure that parties have the ability to go to court for. The second important relief is that of court-assisted evidence taking. So in certain situations where evidence is in the jurisdiction of a domestic court, for instance, if there's an international commercial arbitration, and that the evidence is situated within the local limits of the court, one would have the ability to go to that court and take the evidence for the purposes of trial. And thirdly, for very specific cases of appeal, where from an order of an arbitral tribunal, one has the ability to go to court. Barring these three specified categories, and ultimately for enforcement, there is no other situation in which a court can interfere. The other important amendment, which is also dovetailed into this larger objective, is the definition of public policy. Public policy is a ground for challenge under the Arbitration and Conciliation Act, and it has perhaps been the most abused term and provision in the traditional jurisprudence of our country. Because it was not specifically defined, we were seeing that courts were invariably interpreting and extending the scope and meaning of public policy to include any and all objectives, while determining whether an arbitrator has appropriately applied his mind. So typically, a court would reopen the entire award under the pretext of public policy. Public policy has now been defined very narrowly, and there's a specific proviso which states that it will not entail a review of the merits of the award. It also, in the case of international commercial arbitration, specifies that patent illegality, which is a subset of public policy, will not be a ground in case of international commercial arbitrations. So the legal framework within which courts can decide a challenge against a domestic award and an execution of a foreign award has been severely limited. The next important sort of change is that earlier there was an automatic stay to the operation of an award once a party challenged the award in court. This has been done away with, and the only situation in which a party would have the ability to seek a stay would either be upon deposit, substantial deposit of the money that he owes to the other party, and in case of fraud. Unless these two conditions are satisfied, a court is not competent or entitled to issue an order of stay against the operation of the award. This effectively means that parties would be able to even draw money from the other party while the challenge or the enforcement petition was being decided and determined by court. There is now a fast-track procedure for conducting certain kinds of arbitral disputes. For instance, if parties agree that no detailed evidence is required to be gone into, then they can pass a consent order that tribunal will have the power to issue an award purely on the basis of pleadings. This obviously significantly, fast tracks the process, and we've seen that in certain cases the tribunal is able to issue the award even in 6 months, and that is the mandated period under the Arbitration and Conciliation Act now for fast track arbitration. The interim measures that are passed by a tribunal will now be enforceable exactly as an order of the court, which meant that if an order is disobeyed, order of a tribunal is disobeyed by a party, the direct consequence would be that the opposite party would have the ability to go and sue for contempt before a court, exactly like an order of the court. In the 2019 amendments, certain further significant changes were brought about. The government has now proposed that there should be an arbitration council of India, which will grade arbitral institutions and arbitrators. We now have the Mumbai International Arbitration Center, popularly known as the MCIA, and also the Hyderabad Arbitration Center, which are some of the finest arbitral institutions that we have in the country. They have state-of-the-art facilities, and they are, as good as any and comparable to any other international arbitration institutions such as ICC, LCIA, and CBCI. The Arbitration Council of India's gradation is now not in place yet, but this is a futuristic sort of amendment, and we hope that this will further, revolutionize the arbitration space in India. The timeline for filing a statement of claim and basically completion of pleadings earlier was not specified, so which meant that in the 18-month period, the tribunal will have to ensure that parties complete their pleadings, and they would also have to decide the case within that period. This was working out to be very difficult, so the legislator has specified a specific timeline for completion of the pleadings, after which the tribunal will have a period of 12 months to complete and issue the award. Confidentiality was not specifically dealt with in the Arbitration Act. Now it's been specified as being very, very important. It's a specific requirement of the mandate of the tribunal, and the only situation in which this can be waived is where there is a party needs to make a limited challenge before the court. Arbitrators now have immunity from any legal proceedings, which means we obviously have more incentive for better arbitrators to come on board. And there is now in the 2021 Act, the issue that we discussed earlier, that it has specified a limited ground in which a stay may be obtained, and that is where there is a fraud or corruption. Barring a case of fraud or corruption, no stay may be obtained against the operation of an award. We now have also deleted the 8th schedule to the earlier Arbitration and Conciliation Act, which meant that there is now no requirement for an arbitrator in India to be Indian. This has opened up, a world of opportunities for several international arbitrators, and also for the parties to be very comfortable that their case is going to go before an arbitrator who has experience in dealing with complex issues. We now see very often that arbitral tribunals are being constituted with international QCs, practicing lawyers, and not just judges who are who retired from courts. That was the default option in the older days. This is really recognized space. There have been various interesting judgments that have been progressive judgments, if I may say, that have been passed by the Supreme Court and various high courts. There's obviously a clear mandate now that that as long as the tribunal has arrived at a plausible interpretation, no court can interfere. A plausible interpretation means that there could be, as long as a reasonable person can arrive at that interpretation, no interference is merited. Indian parties can now, under the PASL win solution judgment, choose a foreign seat of arbitrations. Earlier, there was a limitation, and two Indian parties could only choose Indian law, which still is the case, but they could only choose an Indian seat. That has changed now. An award holder now has the ability to secure either a part or the whole of an award amount while the execution petition or the challenge proceedings are pending. The next case is the Amazon versus Future Retail, which is again a judgment that has caused quite a stir. This is a judgment where the Supreme Court has recognized the concept of emergency arbitration, something that doesn't have statutory recognition within the Arbitration and Conciliation Act. The limitation here, of course, is that this only applies where the seat of arbitration is India. In case of international commercial arbitrations, an emergency award, still has some difficulty, and parties have to choose whether they have to file a fresh proceeding or an enforcement petition. The other big change or legislative improvement that is taking place is the introduction of the Commercial Courts Act. This was introduced by the Government of India to reduce the pendency of commercial disputes and accelerate the ease of doing business in India. The Act deals and seeks to establish commercial courts in every district of the country. And above the district level commercial court, there is a commercial division, appellate division in each high court, which decides these commercial disputes. There has been an endeavor to have judges with specific commercial expertise and who are trained in specific complex subject matters who sit in these commercial courts, and it specifies timelines for resolution and speedy disposal of such cases. The Commercial Courts Act also mandatorily requires parties to exhaust pre-dispute mediation as a step before they go on to litigate against each other. This is, of course, a very positive step because we see that a lot of complex commercial high-value disputes are getting resolved through mediation before they go into courts. The other big change that we have seen is through the Specific Relief Act. In the earlier regime, if a party could obtain damages and also seek specific relief, it was, in a practical sense of speaking, a bar. If you could obtain damages, parties would go and seek specific relief, and courts would say, as long as you can seek damages, you should just await, the fate of litigation. The Specific Relief Act now specifies that your ability to seek damages is not a bar to seeking specific relief. and it allows the right to an aggrieved party, as opposed to just being a discretion that was available with the courts. A relief compensation can now be claimed in addition to and not just in substitution of specific performance. An aggrieved party can also choose to get the contract performed by a third party or by his own agency and seek to recover such cost of third party completion from the opposite party. This is extremely important because a lot of infrastructure projects would get stalled and parties would have the ability to only seek damages in court. Courts have now specifically stated in the Specific Relief Act, the legislature has now specifically stated in the Specific Relief Act that courts are restrained from granting an injunction where the contract involves infrastructure. Obviously the test would be that the stay should not impede the progress or completion of the infrastructure project. Special courts have now been established and are empowered to exercise jurisdiction in respect of contracts relating to infrastructure projects. Now, third-party funding is of course a very interesting area, and it's only now coming up. There is still no statutory recognition to third-party funding, but the Supreme Court has now finally clarified that within the framework of law, there is no restriction on third-party funding. The case of GA Senior Advocate and AK Balaji have been seminal in this regard, and they've held that an agreement to third-party funding could be legally enforceable. We have now seen that in several complex construction contracts where parties either have a situation of insolvency or running out of funds, third-party funders have stepped in and have taken charge of the litigation, and that has significantly reduced the burden on the company. Since third-party funding arrangements are, of course, subject to Indian law, courts may have the ability to determine whether the arrangement is unconscionable or not. But within the framework of law, the only restriction that there is on a lawyer funding a litigation. There is no restriction on a third-party funding the litigation. So we are hoping that this is an area that is going to gain a lot of traction and become very, very popular for construction projects specifically. I wanted to just put on a slide some of the things that we think you should watch out for while contracting with PSUs and government entities, because there are some nuances to how courts look at government contracts. Some of the things to watch out for or to make sure that you is streamlined in the contracts. The scope of work and timelines should be well defined, because we've seen that most of the disputes are regarding lack of scope of work, which results in additional costs and overheads, and often results in long-winded disputes. The other confusion that causes a lot of delay in litigation is the technical difference between seat and venue. Parties often do not understand the difference between seat and venue and often put in either contradicting seat and venue clauses or sometimes only the venue clauses. The Indian law is very clear that the determining factor for determining which court will have jurisdiction and what curial law would apply would be the seat of arbitration. So our recommendation always to our clients is that they should only specify the seat of arbitration, and venue should not be added in because it adds several layers of complexity. The other practical consideration to keep in mind is that today, with COVID, in the post-COVID world, most hearings are now taking place virtually, and most arbitrators are opting for virtual hearings, and therefore having a clause of specifying the venue for the arbitration often makes it complex, and it holds the hand of the arbitrator from doing something that's far more cost efficient for the clients. The other important aspect to keep in mind is pre-arbitral dispute resolution mechanisms. Parties often don't have clearly laid out mediation, conciliation, or pre-arbitral negotiation provisions. They are the kind of clauses that nobody really pays too much attention to. But it's perhaps a very, very important phase of the pre-dispute resolution process. And from a practical point of view, we advise our clients to make sure that they put in timelines for parties to go through this process mandatorily before they initiate arbitration. The fourth important aspect is liquidated damages clause. This is very, very important from the perspective of government contracts specifically, because we have judgments of the Supreme Court which hold that, especially in public utility contracts, if a government body or a government company does not show proof of damages, that is okay, because the very nature of public utility contracts is such that it is not possible to determine the loss that may be caused to the public utility, because it usually has a public interest element. It usually impacts several millions of citizens and masses. Therefore, it is very important to make sure that the LD clause is very properly be worded, and it is not worded in a manner that it may be interpreted as a penalty. The use of the word penalty is very controversial and often leads to prolonged litigation. The other, thing that we often tell our clients is that they don't, maintain proper records and correspondence records in construction contracts, and that is what, leads to a lot of confusion during the arbitration. So just, again, a point to keep in mind. Very important from an additional claim perspective. And I think the others are more routine, but an important aspect to discuss here is the deposit of award amount that has been mandated now by the NITI Aayog. The NITI Aayog has issued guidelines that in case of PSUs, they must mandatorily deposit 75% of the award before the court in case they challenge an arbitral award. This is very interesting and very important, because all public sector contracts and public utility contracts would almost always end up in court with long-winded litigation, because public sector officers would be too cautious and would always recommend that the parties explore the last litigation remedy available to make sure that they haven't caused any loss to the public sector undertaking. The introduction of this NITI Aayog recommendation has made sure that public sector undertaking think very carefully before they launch a challenge against an award, because they have to cough up that 75% of the award and put it before court before they challenge. Then, of course, there are several judgments which I can talk about, but I can skip for the moment. But the overview is that it is now very clear, and courts have stated repeatedly, that there is no special or preferential treatment being given to PSUs. They are being put to the same standards, rigor, and test that any other private party is being given. So this judgment, called the PAM Developers Private Limited, the Supreme Court held that the Arbitration Act does not make any difference between a PSU and a private party, and therefore there is no special treatment that will be given to any government as a party. I'll just quickly go over a few case studies which relate to Japanese companies and their investments in India. This I'm sure most of you know. This is the Tata Docomo saga. To quickly give you an overview of the facts, this was a case where Docomo had agreed to subscribe to 26% of the equity shares of Tata Teleservices. There was a provision in the SHA which said that if Tata does not show key performance indicators, then Docomo would have the right to exit the company. The dispute was largely relating to that provision of the SHA regarding the exit. There was a specific valuation methodology that parties had agreed to in the SHA, which said that it would be the higher of either the fair market value of those shares or 50% of Docomo's share purchase consideration. This was obviously a provision that was inserted in SHA, for Docomo's protection, because they should have, at least by their exiting, not go below 50%. This provision ran into lots of controversy because it was litigated heavily or resisted at the time of the award. We can discuss that a little later, but just wanted to give you that context. Docomo announced the exit from Tata's Teleservices because it could not demonstrate that it achieved those key performance indicators, and as a result, Docomo should send them a notice for exit. The dispute went to the LCIA. It was governed by Indian law and it had to be resolved by the LCIA rules. The LCIA directed the Tatas to pay 1.18 billion to Docomo as damages. And the slide doesn't cover it, but I just want to go into the reasoning adopted by the arbitrators for a couple of minutes. The arbitrator said that that provision of the SHA cannot be in violation of the FEMA guidelines or the pricing guidelines, because that's the argument that Tata said, that they are unable to perform or honor that SHA provision because it will contradict with the pricing guidelines, which require that a sale of a foreign investor, a non-resident investor, can only happen at fair market value and not more. In this case, 50% of Docomo's share price consideration was more than the fair value of the shares on that date. The LCIA, or the arbitral tribunal set up by the LCIA, said that that was not the correct interpretation of that SHA, that this was a provision that was meant for protection of Docomo, and it was not a pre-agreed price or assured return that would fall foul of the pricing guidelines and the FEMA guidelines. They said that the award that was being issued now was in the nature of damages, which does not require any further RBI approval. Even at this stage, Tata did not want to comply with the award, so they filed a petition before the High Court, which was of course countered by Docomo's enforcement petition. Tata went back to the RBI, sent them a letter saying that I can still not implement this award because I need RBI approval. RBI sought to implead itself in the proceedings before the High Court and said that I do not permit the consummation of this award because it would be contrary to the FEMA guidelines. The Delhi High Court ultimately said that the RBI cannot intervene and cannot intervene and become a party to these proceedings, A, on the principle that it was a third party to the contract, that it did not have the ability to implead itself in a matter such as this. Secondly, that the fundamental reasoning adopted by the tribunal was that the award was in the nature of damages, and that there was no pre-agreed price. It was only in the nature of a provision that protected the investment put in by Docomo. So just quick takeaways. I think this case very clearly demonstrates that the Indian courts are very, very serious about not interfering or intervening in a foreign award unless it conflicts. It is very clearly demonstrable that it conflicts with public policy. They have taken a position that even a mere statutory violation is not good enough to meet the test of public policy. It certainly demonstrates that there is still goodwill because Tata ultimately settled this case, and the parties entered into a consent award and they honored the award issued by the tribunal and paid them the awarded amount. This case also demonstrates that a third party who is seeking to implead himself in an arbitration proceeding cannot do so easily, and that the bar is very high. There have been certain other cases where third parties have been allowed to implead themselves in arbitration, but those are in the limited cases where third parties operate as alter egos of a contracting party. Barring that situation, courts apply a very rigorous test and do not allow third parties from impleading themselves. The other important and perhaps a case that gives a different flavor to a Japanese case that has come to Indian courts is the case of Ashwini Minda versus Yushin. Ashwini Minda was a shareholder in this company called Yushin, and under the dispute resolution clause, Ashwini Minda invoked emergency arbitration with respect to the shareholder rights under the SHA. The emergency arbitration was invoked under the Japan commercial arbitration rules, and the JCIA rejected the emergency relief sought by Ashwini Minda on the basis that they did not make out any harm would be caused to Ashwini Minda. This was a very reasoned order by the emergency arbitrator, and the aggrieved party, however, filed an application before the Delhi High Court seeking the same interim relief, the exactly same interim relief before the Indian courts. The Delhi High Court said that a party cannot have two bites of the cherry, and that once the JCIA has passed the reasoned order, the parties have chosen a specific international commercial rule that includes emergency arbitral awards, you cannot seek to litigate the issue before various courts. So I think the decision of this Delhi High Court it shows that there is an implied exclusion of the right of interim relief by Indian courts once the parties have chosen a foreign set of arbitral rules. And after availing of the emergency arbitration rules, the parties cannot, litigate the issue before domestic courts. And the Indian courts cannot effectively sit in appeal over an order issued by an emergency arbitrator. Key takeaways, very important to choose your institutional arbitration rules very carefully. There are some rules that, such as SEAC, which specify that notwithstanding an interim relief under the rules, parties would have the ability to go back to a domestic court, such as, in the SEAC case. And therefore, if a party wants to exclude the possibility of domestic relief, then that is something that, one should carefully choose. There is, of course, deference to Indian courts defer to emergency arbitration rules and proceedings and do not seek to interfere. And also, factually, it's very important. I think the courts took a very commercial view here in this case because they did not want a party to unnecessarily prolong and litigate this issue when the conduct itself showed that they were just, taking a chance. I think that's just to give you a highlight. I don't know if I've overshot or spoken less, but thank you very much for giving us this opportunity to speak to you. If there are any questions, happy to take them.
Thank you very much, ma'am. Next, I would like to request Mr. Rudra Kumar Pandey, Japan Desk Partner, General Corporate and M&A, Chartered American Margarita to give a presentation on recent developments in Japan-India investment relations. 続きまして、シャルテル・アマンチャンド・マンガルダス法律事務所、一般企業及び M&A パートナー、ジャパンデスクヘッド、ルドラ・クマール・パンデー様より、日銀投資関係の最新動向についてご講演いただきます。どうぞよろしくお願いします。
皆さん、こんにちは。Sri Shardul Shah, Sri Abhishek Goyal, my friends, and my guests here. While we have talked about legal topic, let me move away from legal topic, and I don't want to make it a little complicated here. So to simplify, I want to recap the relationship between India and Japan. So when we talk about that, we are celebrating 70th year of diplomatic relations between India and Japan. So basically, we go back to 1952, the treaty signed between India and Japan, which basically establishes the diplomatic relation between India and Japan. In 1958, Japan first ever official development assistance that is so common for our infrastructure development was first given in 1958. In 1960, Japan's Imperial Highness, the Crown Prince Akihito and Princess Michiko visited India. At that time, our President Rajendra Prasad, Vice President S. Radhakrishnan, and Prime Minister Jawaharlal Nehru received them in India. In 1982, the big change, auto revolution for India, Suzuki made investment in India. In 2000, the Prime Minister of Japan, Mr. Modi, launched India-Japan Global Partnership with Mr. Prime Minister Vajpayee at that time. This was with an objective to build a multifaceted cooperative relationship with India in wide range of fields. In 2002, again another landmark. In 2002, another landmark, Delhi Metro project, which was supported by Japan's ODA, commenced its operation in December 2002. By now, as we talk about 2021-22, cumulatively, Japan has contributed over 1.3 trillion ODA in JPY loans to establish metro rail system in Delhi, Bangalore, Kolkata, Chennai, Mumbai, and Ahmedabad. In 2006, A joint statement was issued by Prime Minister Manmohan Singh and late Prime Minister Shinzo Abe that the relationship was upgraded from global partnership to global and strategic partnership between India and Japan. In 2007, Prime Minister Abe visited India and delivered a speech, Confluence of Two Seas, wherein they talked about strategic global partnership in which Japan and India will expand their relations. His speech focused on the fact that Japan and India coming together will create a broader Asia, which will evolve into immense network spanning an entirety for Pacific Ocean. It will be an open and transparent network. PM Abe touched upon the ODA from Japan to India and a recurring theme for ODA being forest and water, such as the ODA to Tripura, Gujarat, and Tamil Nadu, on the operating in a way that the people can make a living without cutting down trees and promoting projects that create means to overcome poverty. In 2011, the landmark agreement between India and Japan was signed, Comprehensive Economic Partnership Agreement, CEPA, which basically talks about and covers the aspect related to trade and investments. In fact, there are treaty benefit available, investment protections have been given. The trade between India and Japan has increased under the CEPA regime and also the investment. In 2013, again, Japan Emperors and Empress paid an official visit to India. I can tell you, I was able to meet him in an open meeting invited by the embassy in Japan, in India, and I told him that it's a great achievement for India and Japan what they have achieved together in terms of the engagement in technology, manufacturing, a lot of cooperation between two countries in that sense. In 2016, India and Japan signed again a landmark agreement for cooperation in peaceful use of nuclear energy. In 2021, we have again a landmark agreement and understanding signed between DPIIT, our own ministry, who promotes the investment, DPIIT, and METI from Japan, to explore enhancement of India's industrial competitiveness to enhance the spatial, strategic, and global partnership. As of now, both sides, Japan and India, they do regular meetings how to improve this competitiveness and promote India and Japan investments and technology collaboration. Last slide, 2022. When Prime Minister Kishida visited India, he committed to invest 5 trillion Japanese yen, both in the form of investment and financing from Japan to India. In 2022, as we talk about, as of now, we have about 1,439 companies operating in India, out of which there are 4,790 business establishments in India. Moving to the next slide, key recent development between India and Japan. A lot of initiatives are being taken. As I said, Japan traditional engagement from technology and automotive, it is extending to several aspects of collaboration between India and Japan. In August 2022, FinTech Association of Japan concluded a memorandum of understanding with Gujarat International Finance Tech City, which is a big city, for mutual support and cooperation in development of FinTech ecosystem, acceleration of FinTech innovation and support of FinTech startups. In March 2022, India and Japan announced the India-Japan Clean Energy Partnership to enhance energy cooperation through shared resources and technology, particularly in segments such as electric vehicles, solar, photovoltaic cells, wind energy, use of liquefied natural gas, and emerging fuels, including biofuels, compressed biogas, etc. In April 2021, the Trade and Industry Ministries of India, Japan, and Australia formally launched the Supply Chain Resilience Initiative to enhance the resilience of supply chains in the Indo-Pacific region, to develop dependable sources of supply and attract investment. We have seen some success. Some of the Japanese company with their ecosystem has moved to, they have moved to India, but also they have moved to other part of the ASEAN region. The Government of India and the Government of Japan signed a memorandum of cooperation in January 2021 for a basic framework for partnership for proper operation of the system pertaining to specified skilled workers. It was aimed to foster mobility of workers and skilled professionals from India to Japan. There's a lot of people-to-people exchange has been talked about in our recent visit with the government ministries, and we see that there has been a progress in that segment. Ministry of Textiles, Government of India, and Nishiken Quality Evaluation Center, Japan signed an MOU in January 2021 to provide required support to textile trade and industry for ensuring quality as per requirement of Japanese buyers through testing, inspection, and conformity assessment, training, research, and development. In January 2020, our Ministry of Electronics, Startups Hub, and JETRO signed a partnership agreement to strengthen the Indian and Japanese tech startup ecosystem. Piyush Goyal, the Commerce Minister in 2019, and Hiroshi Kajiyama, the Meiji Minister, launched the India-Japan Industrial Competitiveness Partnership. It was aimed to enhance India's competitiveness in areas such as development and utilization of industrial zones to promote FDI, lower cost of logistics, and facilitation of smooth government process. And we talked about the digital partnership. Moving on to the recent investments from Japan to India, just to talk about the few ones, which are the key investments. Nippon Steel, with their joint venture partner ArcelorMittal, they acquired reports in the power business of SR Group. They made investment about $2 billion. Kubota increased their stake in Sports Limited, a listed company in the tractor manufacturing. They made investment close to $1.2 billion. Toppan Printing from Japan increased their stake in Max Specialty Films Limited from 49% to 100%. $82 million investment they made. This all we're talking about 2021 and 22 investments. Nidec Corporation acquired 96% stake in Mitsubishi Heavy Industries, India Precision Tools Limited from Mitsubishi Heavy Industries. Oryx Corporation, as Mr. Shroff talked about, acquired 21.8% in Greenco Energy Holdings, and they made close to $1 billion investments. Suzuki Motors again announced to invest around $1.37 billion for manufacturing electric vehicles and batteries in the state of Gujarat. Mitsui company, who has been very aggressive in India, they have been making investments across all segments, announced to invest close to 4.1 billion in Punjab Renewable Energy. This is one of the examples that they have been making other investments as well. Digital Entertainment Fund Jet Synthesis announcement of partnership with Square Enix, one of the Japan's largest gaming firm, for developing and launching new gaming titles in India. Dysel Corporation announced to build an airbag inflator manufacturing plant in Chennai and proposed investment in the first phase close to $30 million. NTT Japan has announced to make investment close to $2 billion for data centers in India. I must tell you the trend in the last two paragraphs in 1991 to 2008, the trend was the investment from Japan was largely from drug pharmaceuticals industry, which was accounting about 57%, followed by transportation industry, and which was around 11%, and telecom sector which was about 5%. So that was the trend up to 2008. Now 2000 to 2020, the maximum investment came from Japan in the automobile sector, which accounts for about 19% of FDI inflow from Japan. Services sector, which was about 15%. The drug and pharmaceuticals, which was about 13%. But if we talk about now, Japanese investments has moved away historically, or it's not moving away, but the expansion of the sectors has been happening. Now we talk about promising sectors such as electric vehicles, battery, food, logistics, real estate, green energy, and fintech and startups. That's the sector that we're talking about. Moving on to the next slide. Given I'm getting out of time, so I'll just talk about briefly about the opportunities in sectors. So we talked about auto components. So the current value of Indian automobile sector is about $118 billion. We are expecting that the automobile sector contributes 49% to India's manufacturing GDP and 77.1% to India's GDP as overall. A study done by CEEW Center for Energy Finance recognized $206 billion opportunity for electric vehicles in India by 2030. This will necessitate a $180 billion investment in vehicle manufacturing and charging infrastructure. In the chemical sector again, market size of the chemical and petrochemical sector in India is worth $117 billion. The value of India chemical industry is expected to be $30 billion by 2025. Then pharmaceutical sector, India's domestic pharmaceutical sector is at $42 billion in 2021 and likely to reach $65 billion by 2024 and further expand to reach approx $120 billion by 2030. Food processing, expected value of Indian food and retail market by 2025 is 2025-26 is expected to be $535 billion. Textile and garments again contributes 2% of India's GDP, expected to reach $300 billion by 2024 and 25. Medical devices, where few of the Japanese companies are interested, like Terumo and few others, expected to reach about $50 billion by 2025. Defense and aerospace, India plans to spend $130 billion on military modernization in the next coming years, as achieving self-reliance in defense production is a key target for Government of India. A lot of discussion, ministry to ministry collaboration is happening. We expect that engagement from Japan in defense sector in India will increase. Insurance sector, again, India will be the 6th largest in terms of the total premium volume by 2032 from 10th largest in 2021. I think renewable energy next. I think my colleague Jatin San already talked about electronic systems. The opportunities across electronics, technology, and telecom sector is likely to reach about 1 trillion by 2025. Indian government has introduced the National Policy on Electronics and modified special incentive package scheme to attract foreign investment in this sector. Last but not the least, the SME sector. I think we need more SMEs from Japan. I'll just quote the statement from the JETRO chief in India. He said that in comparison to China, where majority of Japanese entities are in MSME sector, only a few are in large segment. If you see why everybody says that in China, Japanese company is close to 30,000. In India, in total, the Japanese company in India is close to 1,500. The differentiator is the SME company. So, and then in comparison, in India, large companies are operating in a maximum sense. SMEs are in a very limited number. So therefore, we need to have more SMEs from Japan to India. The low cost manufacturing, the labor cost coupled with favorable government policies make MSMEs a lucrative investment segment for Japan in India. It is key to note that the Mercury Japanese investors, companies such as Suzuki Motors Corporation, Sumitomo Corporation, Honda, Mitsui, have successfully established their footprints in India across diverse segments. And thus, it is right time for MSMEs and startups from Japan to take cues and explore investment potential across various sectors in India. It will benefit India by providing boost to MSME sector through funding, technology transfer, and resource integration. Thank you so much.
Thank you very much, sir. Now, we would like to have a Q&A session. If you have any question, kindly raise your hand and let us know. 続きまして、質疑応答の時間とさせていただきたいと思います。ご質問のある方は挙手にてお知らせください。ご質問ございませんでしょうか。それでは最後に第日インド大使館アビシェク・ゴエル様より閉会のご挨拶を申し上げます。Next, I would like to request Mr. Abhishek Goel, Commercial and Political Officer, to give a closing remark.
Thank you, everyone. Thank you so much for joining us today. I would like to especially thank all the speakers, all our friends from Jharkhand, Bachchan Mangaldas, as well as Modi Hamada for their wonderful session. Throughout these sessions, we have covered a lot of ground today, and I hope you gained a lot of valuable insights into the growth potential, as well as the increasing collaboration that is happening between India and Japan. Not just in the energy sector, but in the overall be political, commercial, security, defense. So we have a special strategic and global partnership, and these are the outcomes of that strategic relationship which we share between Japan and India. In closing, we have seen that the energy sector offers significant opportunities for growth and development. As Indian, we are a growing population as well as an increasing demand for energy as the per capita income of Indians increase. India is looking to diversify its sources and strengthen its partnership with countries and partners like Japan. Japan, with its advanced technology and expertise in renewable energy, as well as traditional energy sources, is an important partner for India and has been an important partner for India throughout since the independence, and we look forward towards a transition to a more sustainable future. The increasing collaboration we have seen in our strategic partnership through agreements like what we signed this year, the Clean Energy Partnership, is a positive trend that will likely continue in the coming years. We hope that this seminar has provided you with valuable insights and information on the opportunities and trends in the Indian energy sector as well as the overall India-Japan relations. We encourage all of you to explore these opportunities and interact with our speakers here. And I would also like to ask you to partake in the refreshments. So we have refreshments in the basement. And thank you so much. Thank you, everyone.
以上をもちまして、本日のイベント、インドのエネルギー業界における機会、インドにおける法規制、紛争解決の概要、近畿の日印関係発展を終了とさせていただきます。Thank you very much for participation on the event on opportunities in Indian energy sector, overview of regulatory and dispute resolution aspects in India's recent development in India-Japan relations today. ご登壇いただきましたスピーカーの皆様、そしてご参加いただきました皆様、本日は長時間にわたりお付き合いいただきまして誠にありがとうございました。Thank you very much for your participation today. この後、軽食付きの名刺交換会を地下1階で行いますので、ぜひご参加くださいませ。We will have a networking